Hello and welcome back to Banking Law Advisor. We're talking today about a very important case called Jaftha. This was one of the early cases when the rights of banks and creditors to repossess houses started to be examined. Jaftha takes place in a little village called Prince Albert and was heard in first of all in the Western Cape High Court, well, after the Magistrates Court. And the two people involved, there was actually two cases. There was a Miss Maggie Jaftha, whose name has been given to the case, and Miss Christina van Rooyen, who was the other person with almost exactly the same circumstances. What happened was that there was somebody that obtained judgment by default against Jaftha in the amount of only 632 Rand and 45 cents. Now, okay, this was in 2003, but still that's not very much money even today. In respect of monies lent in advance, so in other words, she'd lent that money to Jaftha somehow. Then what happened was that there was a warrant of execution. The sheriff came, as always happens, and looks to see if there's any movable property. So before you attack somebody's house, you've got to check if they've got enough movable property, chairs and tables and cars and things like that, to satisfy the judgment debt. But in this case, they didn't find any. So what they did is they actually sold her house. And this is what this case was all about. When there's tiny little debts, is it justifiable to sell the person's house for these tiny debts? And then the Constitutional Court found that it wasn't justifiable, that it couldn't happen. But the High Court found that it was, and they had to be overturned on this matter. So this is what we're discussing. How could that actually happen? But it's a very important case, because what's happening now is that what the banks do and what creditors do to try and repossess the debts of debtors is being looked at a lot more closely, and we're coming to a much more reasonable way of looking at debt. On the side of Van Rooyen, in '95, it was quite a while before because this case obviously happened in 2003, she got a judgment by default against Van Rooyen for an amount of 198 Rand 30, so less than 200 Rand, so they're very small debts here. So obviously, to any sensible person, you shouldn't be taking somebody's house and selling it for debts that small, yet that is what happened, and the Western Cape High Court actually decided that was okay. So what the applicants asked for, the applicants being Van Rooyen and Jaftha, they said that they wanted section 66(1)(a) of the Magistrates Court, which is what gives the sheriff and the permission to do this, inconsistent with the Constitution to the extent that it authorises and obliges the clerk of the court if insufficient movable property has been found to satisfy the judgment debt, to issue a warrant of execution against the movable property constituting the home of a judgment debtor where the debt is trifling or there are other and less invasive means of satisfying the judgment debt. So this is what the applicants are asking the court to do, what the High Court refused and the Constitutional Court agreed with, although they gave a slightly different order. Basically saying that when the debts are trifling, you shouldn't be able to repossess somebody's house. And to do that, they asked for something else. They asked the court to declare that section 66(1)(a) of the Magistrates Court Act, to be read as though the following words appear at the end of that subsection. And the words are as follows: provided that no immovable property which constitutes the home of the judgment debtor shall be subject to execution unless the court has so ordered on good cause shown with due regard to the provisions of the Constitution. So, in other words, that's saying that property, somebody's house can't be sold unless the court looks at it and decides that it's reasonable. So that's what that section is saying, that's what they're asking for. And then the last thing, declaring that section 67 of the Magistrates Court is read as though the following words appear: the home of the judgment debtor, if it does not exceed the value, the amount determined by the Minister from time to time by notice in the Gazette, shall not be sold in execution if it does not realise a price which exceeds the amount determined by the Minister from time to time in the Gazette. So basically they're saying that there should be a limit, something the Minister says that unless a certain amount is realised, the houses shouldn't be sold. This is what they ask for. Now there's another twist here, that this house was actually a house built by the state for low income people, and it actually cost the state about 16,000 rand to build the house. It's in 2003, but still it's not very much to build a house for. But the houses are actually being sold, it says, for prices of 500 rand and 5,000 rand and 2,000 rand. So nobody's really winning here, as they generally don't when houses are sold in execution. The state's losing, it's built that house for a poor person and then it's being sold. The person themselves are losing too. Now what order did the Constitutional Court eventually in the end give? It set aside the order of the High Court, and it said this: the failure to provide judicial oversight over sales and execution against immovable property of judgment debtors in section 66(1)(a) of the Magistrates Court Act is declared to be unconstitutional and invalid. So in other words, to sell a house in execution without judicial supervision, without the court saying that that's okay, is now unconstitutional after Jaftha. So this was a major case. And then it says, to remedy the section of the Magistrates Court, 66(1)(a), that we discussed about earlier, is to be read as though the words, a court, after consideration of all the relevant circumstances, may order execution. So you see the way the Constitutional Court likes to give, it didn't give the specific things that was asked for by the applicant, but it said that the court must consider all relevant circumstances. The Constitutional Court doesn't want to say definitively what must happen every time, because circumstances differ. It just says that the court at the time must consider all the circumstances, with the implication that if it had considered the circumstances in this case, then they'd never have ordered execution for such small amounts of debts. Thank you for listening, and we'll be back again with Jaftha, more information on this case of Jaftha. Thank you.